I'm continuing the Illinois State Constitution, page 16, Article 1, Bill of Rights, Section 17. No discrimination in employment and the sale or rental of property. All persons shall have the right to be free from discrimination on the basis of race, color, creed, national ancestry, and sex in the hiring and promotion practices of any employer or in the sale and rental of property. These rights are enforceable without action by the General Assembly, but the General Assembly by law may establish regional exemptions relating to these rights and provide additional remedies for their violation. This provision was new in the 1970 Constitution. The committee proposing it at the Constitutional Convention intended to go beyond non-discrimination requirements, applying only to government action, and reach private actions as well. But the committee did not intend to forbid discrimination by voluntary associations. An Illinois appellate court decision held that this section does not prohibit private clubs in Chicago from denying admission and service to women, including that such clubs are voluntary associations. One judge dissented, arguing that such clubs play an important role in the business and professional activities of the Chicago metropolitan area. Interaction with Human Rights Act. The Illinois Human Rights Act, which combined several anti-discrimination laws in 1980, implements the guarantees of this section. I was 7 years old, 2 years before I got adopted. Implements the guarantees of the section. Before the act took effect, the Illinois Human Rights Act, which combined several anti-discrimination laws in 1980, implements the guarantees of the section. Before the act took effect, Illinois courts had allowed some suits under the section against employers for discrimination based on sex. But the act says, except as otherwise provided by law, no court of the state shall have jurisdiction over the subject of an alleged civil rights violation other than as set forth in this act. The Illinois Supreme Court has therefore held that the act is now exclusive remedy under Illinois laws for civil rights violation in employment. The court said that the General Assembly in the act has established reasonable exemptions relating to those rights, as allowed by this section, including the exemption of employers with fewer than 15 employees. Decisions by the Illinois Appellate Court in 2 districts have held that this section applies only to hiring and promotion. Practices narrowly construed, not all employment practices such as those on employee relocation and dismissal. Illinois Appellate Court decisions in 2 other districts have held and implied that the section of application is broader. The Illinois Supreme Court in 1994 case mentioned this issue but found no need to decide it then. Section 18. No discrimination on the basis of sex. The equal protection of the law shall not be denied or abridged on account of sex by the state or its units of local government and school districts. This provision was new in the 1970 Constitution. It shares with Section 17 a prohibition on discrimination by sex. But while Section 17 applies to businesses and prohibits only discrimination in business transactions, this section applies to governments and prohibits virtually every kind of sex discrimination by them. The Illinois Supreme Court has held that this section makes sex a suspect classification in Illinois, meaning that any law, regulation, or ordinance discriminating by sex must have a compelling governmental purpose capable of withstanding strict judicial scrutiny to be upheld. Illinois courts accordingly held unconstitutional former sections of the Juvenile Court Act that discrimination between male and female 17-year-olds for purposes of the act. A law setting different minimum ages for marriage depending on gender. And an ordinance prohibiting persons from providing commercial massages of persons of the other sex. On the other hand, the Illinois Supreme Court upheld a law setting a higher penalty for aggravated incest that between a father and a daughter than for other incest. The court pointed out that incest by a father has greater potential harm for harm than incest by a mother and occurs far more frequently, thus justifying harsher treatment. I was raped more by women in my past 52 years than by men. And it wasn't my mother. It was my aunt and first cousin and their friends. And occurs far more frequently, thus justifying harsher treatment. However, the General Assembly later amended the law to make it sex neutral. And it should, because you're discriminating just that men do it more frequently. Yes and no. They might get found out more. An Illinois appellate court decision upheld a law prohibiting bar owners from employing women to ask patrons to buy them drinks, stating that such solicitations by women are far greater problem than solicitations by men. Although the Illinois Supreme Court has not ruled on this issue, a large majority of Illinois appellate court decisions on the subject have held that there is no longer a presumption in divorce cases that a mother is more fit for a child custody than a father. That's true. But the biological parents are always best. And if the biological parent has a federal or even a state record or an international record, you got to be very careful because they are typically very unsafe people. So, peace out, we the people, especially Illinoisans. Have a great day, week, month, whatever it is until next time. Peace.